Welcome back. The ANC has its work cut out in the aftermath of the Section 89 panel's Phala Phala report. The NEC met briefly today, postponing the meeting to allow the National Working Committee to review the report, after which the NEC will meet again before Tuesday. It has to happen before then, as the 6th of December is when MPs will debate the report and decide if an impeachment committee needs to be established. Let's unpack the matter further and get a legal perspective from constitutional law expert advocate Michael Osborne. Thank you very much, Advocate Osborne, for joining us this evening as South Africa very much sits on tenterhooks amid uncertainty, and no doubt the president is overcome by uncertainty at this stage as well, consulting to get various opinions. Before we get to any options open to him, let's talk about the report itself. It does not constitute an investigation, and it has made no finding on the president's guilt per se. So what legal weight or goal does this report have?
Good evening to you. The report has the function of, the process, the Section 89 panel process has the function of acting as a kind of a filter. The first step is that a complaint is raised to the Speaker. The Speaker then considers whether it's worth pursuing any further. If the Speaker does consider that it merits looking at any further, she will refer it to what's called the Section 89 panel. The Section 89 panel is nothing akin to a court of law or even a commission of inquiry. It has no subpoena powers. It may not demand documents from anyone. It performs a purely passive role in essentially reading documents that are given to it by whoever chooses to give it documents. It will then present a report, as it did on Wednesday. That report will then go back to the Speaker, and the Speaker will then give it to an impeachment committee, which is the equivalent of any other committee of Parliament. The impeachment committee will then consider the report and then make its own report to Parliament, which will then vote on the report and decide whether to impeach the president, which it may do so only by a vote of 2/3 of its members.
So as you've said there, this panel cannot request or subpoena any documents, it cannot interview people. But despite the inquiries or the panel's limited powers and access to information, there are still 3 very senior judicial minds behind the report presented. Do you think that report is correct in having found that the president has a case to answer to?
Well, I can't answer that myself. I haven't looked at the underlying documentation. What the committee's report, the 80-page report, does is present quite a detailed summary of material that was placed before it, only written material that was placed before it by the complainants, which would be the EFF, the ATM, the UDM, and then some responses from the president. The panel made a point of noting that it had not heard anything from the South African Reserve Bank, which apparently has conducted its own investigation, nor has it heard anything from the Hawks, which also has been conducting its own investigation. So in its summary and its prima facie view of what was placed before it, the panel went out of its way to say that it had this limited prima facie passive role, and that it had not had the benefit of input from other parties that were conducting investigations of their own, and furthermore noted that a great deal of the material before it was hearsay. Key players are relied upon. No affidavit or sworn testimony is to be had. So, yes, not to answer your question, I cannot say whether the Commission's view that there's a prima facie view, that there's a prima facie case. I can't say that because I haven't had the benefit of looking at the documentation that they saw.
Let's talk about the president's next course of action. Reports from close to the president suggest that he has been advised to fight back and to take this report on review. How does that work, and what processes unfold from here in what time period?
In principle, the president would have 6 months to bring an application to the High Court to review and set aside the panel's report. However, one assumes that he would want to move a lot more quickly than 6 months because this report will now go to the impeachment panel. And I assume that a calendar has been set up such that the committee in Parliament will want to begin looking at it sooner rather than later. I must say, though, that the Parliament may be convening in the coming week, but it won't be the plenary Parliament that, in the first instance, will be seized with this report. It will be a committee of Parliament that will look at it. And I imagine that could take a fair amount of time. There's enormous detail here. So I don't think one can anticipate that Parliament as such will be voting next week or even the week thereafter.
So still some time for a number of processes to play out. We know, as you've already mentioned, there are several other investigations also underway concurrently. The Reserve Bank, the Hawks, SARS, the Public Protector, they're all looking into various aspects of this saga. What are the legal options open to the president, and what role do we expect these other investigations to play in the coming months? Because impeachment is not the only worry, certainly, if there are perhaps criminal charges or things that the president needs to answer to.
Yes, well, at inception, the option is to, as I've said, bring an application to review, which would go to the High Court. As to whether criminal charges are to be brought, I suspect that's still quite a long way down the line. We don't know when the Hawks or SARS or the Public Protector will come back with their investigations. So we face at the moment a rather unsatisfactory situation where we've had a huge amount of investigation going on. All we have right now is the report produced on Wednesday by the panel, which is very much aware of its own limitations. And in the introductory section, the report states several times over that it's functioned under these rather constrained circumstances. It can only make a kind of a desktop analysis of what's before it and come up with the conclusion that if these allegations, most of which are hearsay, if those are to be proven, then there is a reasonable possibility that the president will be found to have committed impeachable offences. That's all we have now.
Thank you very much for sharing your insights with us. That was constitutional law expert advocate Michael Osborne commenting on perhaps some of the president's legal options and processes that are yet to unfold.